No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight it's again time to open the lines for you to ask that legal question that doesn't quite fit into the other topics we discuss here on the Law Report. And just always a reminder that we are not taking calls on property law or labour law, because those are topics that we actually have their own program, so they are discussed in full. And Michael Bagram will be back with us doing a special program next week on the 15th. So if you have any labour law questions for that, then you can call in then, or the last Monday of the month is when we do property law with Ishmael Mohammed. But tonight it's the law clinic, so everything else except property and labour. And joining me once again this evening is attorney Nicoline Skuman-Low, and she's a director of Skuman Law Inc., Attorneys, Conveyancers and Notaries Public. Nicoline, good evening. Welcome back to the show.
Hi, thank you as always for having me.
You've had a very busy time since we spoke last. You've been moving offices.
Yeah.
Quite exhausting work.
Quite exhausting, but we're very happy in our new location. So all the hard work, blood, sweat and tears have definitely been worth it.
Correct. Well, we've just got one email we're going to deal with, but you can call us now if you'd like on 0892 10 2010, 0892 10 2010. And as I always also like to remind you, don't leave it until the last minute, because then we can't get you on and we then have to finish the show. And I really don't like leaving all those calls unanswered. If you don't want to call in, we prefer you to call in so you can speak directly to Nicoline. But if you'd like to SMS us, the number is 40938, 40938. Right, Nicoline, the one email that we did get was from a listener who's had a fees dispute with a particular school. I'm not going to mention the name of the school. It was for 1,600 Rand. And in 2015, the sheriff of the court, he says, broke into his house and repossessed furniture worth 28,000 Rand instead of taking items which were worth just the amount, which was 1,600. He's laid a complaint and they've never cared, he says. They've just obviously ignored it. And so instead of just getting back property worth 1,600 Rand, they've taken stuff, he says, worth 28,000 Rand. I mean, what can he do?
You know, these are really difficult situations. Often, it happens that a judgment is taken for a debt, regardless of how the debt came about. And then when you get to execution phase, in other words, where the sheriff comes to repossess or collect some goods for purposes of selling them at auction, you often find that the sheriff either attaches goods that do not satisfy the debt. So the converse to the situation could also happen. Or the sheriff attaches a range of goods that maybe have been acquired at a higher price than what they are actually sold for. So many people go to these sheriff auctions for purposes of bargain hunting, really, because we often find that the goods that are repossessed or that are possessed are often sold very much under their real or market value. So it may very well be that the listener has been finds themselves in this situation because the furniture concerned was maybe newly acquired and it has that value. But unfortunately, it's not an exact science, and repossessions can happen either where things are attached that are worth much more than the debt, or you conversely have the situation where goods are attached that don't even closely satisfy the debt. We must also look at this debt and see that it may have a long history. In other words, it may have been incurred before legislation prevented the interest to equate to the capital, the in duplum rule, in terms of the National Credit Act. So there may be a lot of reasons that this may be more than 1,600
Because he said it in
rand.
2015, the sheriff came and attached the goods. So it's not that long ago,
But it doesn't
really,
mean
that the original debt was incurred.
The debt could have been incurred a while ago. Judgment could have been taken a while ago, and interests and administrative fees and legal costs could have accumulated to make it much more than just the original amount.
But would he not then have received some sort of paperwork explaining all of that?
Yes, definitely.
So you would have had that.
You know, let's quickly move on to the next issue now that I've explained some of the situations that we see in practice about attachment being not satisfying the debt, and then, of course, excessive attachment, let's call it that for ease of reference. That the sheriff broke into the property, that's a problem. Of course, there are legal ways and means that the sheriff will enter a property. But of course, if we accept that this is what really happened, then of course a complaint needs to have been lodged with the sheriff's board, and if it hasn't enjoyed any attention, then perhaps the listeners should seek legal advice and escalate it.
He says he has laid a complaint, but they didn't care, he says.
Unfortunately, it does take some time to investigate complaints, and of course, you can imagine
2 years.
that the sheriff's board does get a lot of complaints are lodged with them, so it does take time. And 2 years seems fairly plausible, but I would say this really needs to be unpacked a little more, so that one can understand the situation at hand, and maybe look at the paperwork, get a copy of the court file, see how much this 1,600 rand perhaps escalated to, see if the goods were sold, when were they sold, at what price were they sold, you know, to get a bit of a feel in more detail as to what has actually happened from both sides of the story, and then to assess the next steps.
If it was sold for more than the debt, can he claim whatever there was in excess? I mean, would they even tell him there was excess money?
That's really difficult. There should be paperwork with the sheriff's office, of course. But again, if one wants to dig into what happened after the collection, obviously it's either in storage or it's been sold. And if it's in storage, then the person who the debt is owed to is paying storage fees each month. So it seems unlikely that it's still in storage. It's probably been sold. But all of this is properly recorded. And if you have a case number, then there are ways and means of getting this information and seeing what happened. And then, of course, assessing whether or not a claim is plausible.
So there is something you can do, but it takes
Definitely.
a bit of work. It's almost like being a detective here.
You'll have to dig a little deeper. As I say, starting to get a copy of the court file is a good start, so that you can see exactly how the debt accumulated, where did it come from, what interest did it attract, legal costs, etc., etc., etc. And then, of course, the big question: the sale. When did it happen? Where did it happen? Was it advertised properly? Was process properly followed? And this may even escalate a potential complaint or even a claim. But you need to dig a little deeper.
Right, if you have any questions for us, 0892 10 2010, 0892 10 2010, or you can SMS us on 40938, 40938. We've had an SMS, Nicolene, it's about SASSA grants. Can you help with anything to do with SASSA grants?
Well,
it's not too involved. Basically, Eros wants to know, he says, how does one get a SASSA grant account bank interim statement for one to check transactions processed without one's consent? Now, there has been quite a lot of about things coming off those payments for all sorts of things.
Yes.
And they have been looked into. But from what I heard, you have to go directly to SASSA to ask them about that.
That's exactly what I heard as well. So if there's if anyone has any information for us, maybe for some other avenue, feel free to share the information with us. But as far as I'm concerned, you would need to approach your local SASSA office.
And he just basically wants that grant account bank interim statement. So, I mean, he would actually have an account. Well, that is if you're having it paid into a bank account. But some people go straight to a supermarket and get it. Would you have how would you get some sort of an account of your payment, if you like, if you aren't paying it in? Where would there be one? I'm sure there must be one.
There must be records, and from my understanding, I agree with you. That happens directly at the SASSA office. I know that they are subcontracting the administration surrounding the payments, but they are the ones collecting the information and controlling it to a large degree. So if they can't assist, perhaps they can point you in the right direction. I'm sorry that we're not more helpful
No,
than
it's
that.
not something that we actually would be able to have access to, or anybody other than SASSA or somebody appointed by SASSA would actually have access to those statements. No, you wouldn't be able to get them anywhere else, I wouldn't have thought.
Definitely.
So, right,
Sorry about
unfortunately,
that.
Eros, you're going to have to go to SASSA and speak to them and ask them about getting hold of a copy of that account. And I'm sorry to hear you having things taken off, because there was quite a lot of, when we had all those problems with the last payment,
yes.
there were a lot of people then, again, that were saying this was supposed to have been sorted out, but there's still being all these deductions. So, not a good situation to be in.
No, definitely not.
No. Right, so if you have any questions, because you've run out of emails now, and if you'd like to SMS us 40938 or phone us on 0892 10 2010, 0892 10 2010. Just one thing before we go to the calls, because they are coming in now, I see. I've had a few requests from people wanting to know, when is it Wills Week again? They're very keen now to get other people. I've had some emails from people who've had their wills done, or have had people, they've encouraged other people to have their wills done.
Oh,
but
great.
now want to encourage more people. So when is it happening again? It's normally September or something around there, isn't it?
September or October, usually either mid-September or early October. But the Law Society does publish it round about June. We get the dates then, and participating attorneys' firms can then fill in the forms and get their ducks in a row to start participating. So definitely something to be on the lookout for. The minute we get that, that they are that news, the circular that the Law Society actually sends the attorneys, the minute we get that, we'll share the details and the information with the listeners.
We actually had, I think when you weren't with us, you were away, I think, and the 1 week, and we had somebody from an organisation in Khayelitsha who has this organisation was Grannies Against Poverty and Gangsterism, whatever else, and one of the women in the office had got a number of their clients to get their wills done last year, and she was one of the ones who phoned in and said, when can we do this again, because there's so many more people that she'd like to get involved.
That's fantastic.
So
Yes.
so it's nice to know that there are people out there waiting for this, and it's one of those things we encourage you to do. So as soon as we know about it, Nicolene and I will let you know how to go about it, and as I usually do, send you lists of participating attorneys in your area, which is what I do, so they can find them to go through scrolls of them. They say, where are you in the country, and I send you a list of where you can go. So hopefully we can do that. Right. I think we might have our first. No, not quite yet. He's just being put onto the phone. We're talking about medical aid and things. So we're going to be talking about that. You happy talking about medical aid? Not quite sure what exactly the question is about that, but we're coming up about that.
Maybe we can assist.
Right. But in the meantime, we're talking about wills and that sort of thing. As I said, we're going to tell you when the Wills Week is coming up, but it is one of those things that we need to just encourage people yet again. Why do we need to have a will?
Well, I think
some people say, well, I don't really have anything.
I hear that a lot, and with all due respect, that's not really what it is about. I've said to many clients over the years that it's not really about how much you have, but it's about a large degree of administration, really. So think of it this way: if you have any debt, and most of us incur debt to go and study, then that's a trigger for you to have a will. Because if you don't provide for what happens and how will the debt be serviced, it inevitably becomes someone else's problem. So there are very easy mechanisms of dealing with the debt. Usually in the case of a bank loan, regardless of what the purpose of the loan is, you'll have a life insurance policy attached to it. So as you repay the loan, the life insurance really gets adjusted, so there's usually a bit of a balance that gets paid out to whoever you choose. So it's really important that you think of these things practically and think, so if something were to happen today, what would happen to the debt? Those things that I do have, even if it's not much, who would you like to leave it to?
Because you don't want there to be a fight after you die.
Yeah, and I think if we think of younger people, I mean, with study loans and so on that I just mentioned, I think maybe they don't, it's not their reality that someone will fight. It usually defaults back to your folks. If you are not yet married, if you don't have children, then it's sort of, I think then you can perhaps reason it away. But again, I maintain if you have debt, you need to look, you need to be responsible, be a grown-up about it.
Because your folks could end up having to pay for it.
Exactly. And it really does complicate things. So if we look at other stages of life, when you get married, when you have children, all these are triggers that change your life and that probably change the way that you look at things. And then it could, for example, become quite relevant who gets what. And the conflict situation may become quite relevant to you in that situation. As life changes, you need to adapt. Even more so if you own a business. What about your business? What about your employees? Who's going to access the banking account? So one needs to think of the continuity of things.
I'm always, my fanatical thing is children. You've got to put a plan in place. You've got to make sure you've got guardians in place. Heaven forbid something happens to both of the parents. So as your child grows, that will has to keep changing.
Exactly.
All the time.
The needs change.
The needs change of the child. How's that child going to be supported? Are there policies there? Are there guardians in place? I mean, you've got to think not only of yourself at this point.
And even if the guardians are in place right now,
they could change.
Most of us, if you're lucky enough to still have your own parents around, you select your parents as the guardians of your children.
But as they age, you might want to have somebody else.
Exactly, or maybe they are simply not in a position to take on such a task. So one needs to think about these things very practically, and you need to adjust. You can't just have a will done now and leave it for 20 or 30 years. Things change.
And I do know some people who have done that, and
I do as well, and I'll rather not say.
I'm becoming very unpopular because I tend to nag. Have you changed your will yet? And they say, you will get to it. And I think, well, eventually, okay, fine. I've now said it 10 times. I can't anymore.
No, it's very important. And I know for some people it's a very gloomy topic, but it really need not be.
No.
It's really all about what has your life's work amounted to, and how would you like to leave that legacy behind, really? It's actually quite a marvelous thing to be able to plan. It's actually, in my view, not depressing at all.
Or maybe there's something wrong with us.
It's all about the mark that you wish to leave behind. I think that's very powerful.
Right, we've got some calls, we've got some SMSs. Let me go to the first SMS now because that did come in first. It says here, I had a contract with a gym. After signing up for a gym contract for 12 months, soon after I had not been able to pay due to financial constraints as I'm a student. I further cancelled the membership and was told to pay 60% of all the premiums. This I did not. Now. This I'm not quite sure. No, as this other consultant I'd signed up with didn't give me the full picture of the contract or tell or explain it all. And now I'm unable to pay the gym. So he was basically told if he cancelled the membership within the first 12 months, because that was what he'd signed up for, was now told to pay 60% of all the premiums. I didn't know this because the consultant had signed up with didn't tell me this, didn't give me the full picture of the contract.
That's a very unfortunate situation. The Consumer Protection Act, luckily, has put some legislative framework in place in terms of fixed term contracts, whether it's lease agreements, gym memberships, as case in point, mobile phone contracts, etc. And it allows a consumer to cancel with 20 business days notice, so a calendar month, provided that you pay a reasonable cancellation penalty. And that's where the complication comes in. It's not been defined. So in the leasing industry, anything between 2 and 6 months is an acceptable standard for a reasonable cancellation penalty. I'm not aware of the cancellation penalty that is industry standard for this type of contract, but 60% does sound excessive.
So what should this listener do then?
Report it to the Consumer Tribunal.
And they would be able to help.
Yes,
right.
And it's an ombud structure, so it is
not going to cost anything.
Not going to cost anything. So you contact the local. They are national also. They've got branch offices all over the country. They've got forms that you can complete and friendly staff that can assist and direct you on how to complete the documents, and then you wait for the outcome. Right,
on to the first caller, Brightish in Pretoria. Good evening.
Good evening, Haran. How are you?
Very well, and you?
All right, I just wanted to know from the legal experts. I have my fiance is working with Nedbank in Rustenburg, and I have my medical scheme. I've been sharing with her and my child. Right now, she called me that they have forced all the workers to sign their own company medical scheme. And she cannot share two medical schemes. She mentioned and she informed them that I'm sharing my medical scheme with my fiancé. So tomorrow, they said if she does not sign the medical, scheme of the company, she's going for a hearing or she may lose the job. Is it legit that a person can be forced to sign a medical scheme that doesn't want, or a person to share two medical schemes? Thanks very much. I'll be listening.
Okay, thanks, Brajesh.
Goodness. Now, usually it can't be compulsory. A company could obviously have a preference to medical schemes, but of course benefits attached to a salary, that's to be negotiated between employer and employee. You can't roll something out as unilateral as this. So it doesn't, in my opinion, it doesn't sound right. It is a fact, though, that you cannot be a member of more than one medical scheme. That is so. But the fact that a company is trying to force all employees to take part in a
and
medical
the disciplinary
scheme,
hearing, and she may lose her job. She's got such a case at the CCMA, in my view.
Yes.
If they do that.
Yes. So it doesn't sound right, and threatening job security as a result of it. Also, that without any further question is irregular. It's
Brajesh, if I may make a suggestion, next Monday we are going to be doing labour law with Michael Bagram. Why not call in again next week? Or maybe we've actually got your number, Brajesh. We'll call you during the show next week and let Michael Bagram, who is a labour law attorney and will know more about this kind of thing, we'll call you next week and then he can chat with you about that. I don't think he's going to like that one particularly. He might give you the same answer I did. She's got a really good case if they do that, to go to the CCMA.
Yes.
I don't think they can force her to do that.
No, of course
and not threaten her job
Essentially, it's an amendment to your employment contract. And amendments need to be negotiated and agreed consensually by both parties, employer and employee. It's a fundamental principle. As the employer or employee, for that matter, you cannot impose unilateral changes to a contract that the other party is not hasn't agreed to. So it's an unfair labour practice in my view, but again, Michael's the expert. So.
He'll probably agree with you 100%. I even think you're right, and I don't really know much. Right, okay, we'll just take one quick SMS here. It says, is it possible to inherit a deceased person's debts if you are named as a beneficiary and the will's liabilities exceed the assets?
Technically, yes.
Oh dear.
You can inherit debt. And let me explain what I mean by that. In a situation where you are an heir, whether you are mentioned in an insurance policy as a beneficiary or if you are mentioned in a will, and the executor is doing the accounts and collecting all the assets and paying all the costs and liabilities, and it turns out that there's just too much debt, then the estate, or rather the executor, is faced with one of two decisions. He or she either starts to sell some of the assets in the hope of raising enough funds to pay all the liabilities. If that can't happen, if there just isn't enough to go around, then it becomes an insolvent estate, which means either the heirs must pay in to retain the assets, or it gets handled like an insolvent estate. So everything will be made into cash and everyone will be paid cents in the rand. And in that context, then you don't inherit the debt, but you don't get anything.
But at least you don't have to go and take out a loan for it.
No.
Hopefully what's in the estate can be paid to
You
to
either
cover
take
it.
out a loan so that you retain the asset. Let's think of maybe
house or
a
something.
house or a family heirloom that will be sold as part of this. If it's about the sentimental value,
True.
yes, then you may find yourself inheriting the debt, having to service debt in order to retain the asset. Or everything just gets sold and everyone gets cents in the rand.
Right, and there's two SMSs here, one from Moss in Witbank and one from Jacob. Both of those are labour law related. So I have got your names and your numbers, Moss and Jacob, and we will call you next week, Monday, when we're speaking with Michael Bagram. So we won't be answering your questions now, but we will phone you during the course of the show next week, and you can possibly SMS us, or I'll put your questions to Michael then. Right, our next call on the line, Shando in Durban. Good evening.
Good evening, Carol. Thanks for taking my call. Good evening to both of you ladies.
Pleasure. How can we help?
Yes, please, very quick. Is there any other cause I can take? I've just discovered that in terms of the law, when you owe money, you have a certain period in which to claim, failing which then your debt is never recovered, covered, so to speak. Excuse my language, my English. So, is there any legal means in which I can actually overcome that, or I can claim the amount owed to me by somebody?
Well, it depends on how long we're talking about.
We're talking about, excuse me, may I interrupt you, Carol, please, lady? Well, apparently it is 5 years. I've exceeded 3 years. I'm told it's only valid for 3 years, but the amount was for purchasing a property, and it's been 5 years. I wasn't aware of that legal jargon until now. Just been legally advised that it's no longer I no longer have a case. Is there any other means in which I could pursue this better?
Unfortunately not. If a debt or a claim has prescribed, and it's a 3-year period generally speaking, then unfortunately it extinguishes your claim. The only way that you can interrupt prescription, in other words, that the 3 years stops running, is if you've issued a summons.
Apparently so. I was not informed accordingly, and no summons was issued legally. So therefore, I was just write it off.
Can you not apply for condemnation, or is it now too late?
You can try, but in my experience, that is never entertained. The court looks at it. If it sees it's an old debt, you can try and make the argument, but I suspect you'll be wasting your money.
What kind of argument? Please repeat that statement. What course can I apply with my trail?
You can still try and issue a summons, and if it gets to court, you can argue your case and say you weren't aware of the prescription period. But remember, there's a general provision in law that ignorance of the law is not an excuse. So I suspect you'll be wasting your money if you follow that route. So I'm sorry.
So therefore, I must just forgive us.
Unfortunately, that would be my recommendation. But of course, you're free to seek a second opinion.
I understand. Thank you very much indeed, ladies.
Sorry, Shando.
Very helpful indeed. No, it's all my fault. Thank you very much indeed. Good evening.
Thanks so much. Good night, Shando. It's a very sad story.
Yeah, it's really unfortunate, and I think we need to maybe quickly remind listeners that you need to ensure that if you have a claim, regardless of where it stems from, if it's debt that's owing or any legal claim, any legal right you wish to enforce, you need to do it within 3 years. If you don't do it within 3 years, then you may find yourself in the same position. It's very different to not complying with court terms. In other words, if you have 10 days to do something and now you do it on the 12th day, that is a condemnation argument. Which could succeed, but prescription goes to the root of the claim. So it's unfortunately, once it's prescribed, it's done. You can't resurrect your claim. None, to my view, none of the arguments trying to achieve that have ever been successful. So
it's always a case. I always say, if you've got a problem, don't leave it till next week because you might forget. Do it tomorrow.
Yes.
It's always a case of do it sooner rather than later.
Definitely.
Right, we've suddenly got a pile of SMSs here. We're going lots and lots of them. But let's see if we have any calls. We've got Delilah in Cape Town on the line. Delilah, good evening.
Hi, good evening. I have a question. My mum passed away a few weeks ago, and my dad is trying to take her off the medical aid. I've sent all the forms through. I've sent the death certificate and a certified copy of the marriage certificate and her ID. The medical aids now come back saying, fine, they will take my mom off my dad's medical aid once I provide them with the letter of executiveship, letter of authority, and the power of attorney, which makes absolutely no sense to me because the power of attorney doesn't pass on once someone's deceased. And I don't understand why they need that in the letter of executorship, because surely if my mother was still alive, my dad could still take off the medical aid anyway.
Yeah, it's quite strange that they would request that, because most institutions are usually satisfied with receiving the death certificate. But perhaps it's some internal mechanism that they use, or internal process that they have. The reason from a legal perspective that they could be requesting the letters of executorship is to ensure that the person acting on behalf of the now deceased estate has the authority to do so. So it's a legal technical argument, if anything.
Yeah.
Power of attorney that they're referring to is usually if you, in the case perhaps of an attorney, for example, if your mother had appointed yourself or your father as an executor, then you are free to appoint an attorney to act on your behalf. And that would be a power of attorney that you'll grant to that attorney. So that's usually the document that they want from you. You're quite right. A power of attorney signed by a deceased would obviously have no value at this point.
Exactly, yeah. Because I thought that the letter of executorship and the letter of authority is only to do with property, once you want to sell out of a deceased estate.
No, all estates must be reported to the Master of the High Court, and you need to apply for, if it's a small estate, under the threshold has recently been increased, but I believe it's 150,000. Then it gets a letter of authority. If it's a large estate, it gets a letter of executorship. So all estates must be reported to the master, and you must fill in the forms and go through the process.
Okay, thank you so much. Thank you.
Before you go, Delilah, I remember when many years ago my dad died, all we needed to do was provide a copy of the death certificate.
Exactly, right.
And that seemed to be okay then.
Now.
This was quite a while ago. So, but gosh, no, this sounds like a bit of a nightmare.
It does, because when someone passes away, the last thing you think about is all these documents and getting letters of authority and executorship, and like I said, the power of attorney doesn't even exist in this case. I mean, there was never power of attorney because my mother was not senile or whatever.
No, but I think that the power of attorney that they're referring to is if the executor who is going to deal with the deceased estate has delegated their power to an attorney, for example, that's the power of attorney that they'll want. So that whoever they are speaking to has the legal authority to direct them to do what you are asking them to do. It's all about legal authority in this case. It is a little... But
Delilah made a good point earlier, because, I mean, is the medical aid in your dad's name, Delilah?
Yes, my dad's the main member.
That's what I'm asking. I mean, at any point, your father could just get it into his head and decide he didn't want your mother on the medical aid and could have her removed at any point. Yes. But now there's this drama. I mean, why? I mean, I can't understand why there is this drama.
That's exactly what I was saying at the beginning of the question, is that it's... To me, it sounds like someone somewhere wrote a rule and someone probably interpreted it incorrectly. Because usually with financial institutions, the letter or the death certificate is sufficient for making such changes.
This is just a medical aid, for heaven's sake.
Yes. So it should be enough. But I know some of them may go through the argument of, but now this person is deceased and the only person who could legally represent them is the executor. So you need to appoint that person, otherwise we don't see you because you don't have the authority.
Yes.
It's a technical argument, but I think they're overcomplicating it. I agree with Karen, but it is what it is.
Somebody doesn't have enough to do, Delilah, obviously. Well, good luck with that. I wish you much luck, because
Thanks so much.
These sorts of things can give one a nervous breakdown. So good luck with that. I hope you'll stay well going through the situation. Good luck.
Thank you. Thanks so much.
Thanks. Good night. Bye-bye. Right, you're listening to The Law Report. It's our monthly law clinic with attorney Nicolene Skumanlo. And if you'd like to call in, we've got 20 minutes left now. If you'd like to call through, 0892 10 2010, 0892 10 2010.
Hope, courage, strength.
At Reach for a Dream, these are not just words. They are the emotions that inspire children with life-threatening illnesses to dream. Join DJ Fresh, Lyra, Roxy Berger, Carol Boyce, and Gert Johan Kutsia in supporting Reach for a Dream. Support Reach for a Dream. Get your Slipper Day wristband from reachforadream.org.za and wear your slippers on Slipper Day, 12 May 2017. This is an SABC Foundation initiative.
No one lays down the law like car and key. This is the Law Report on SAFM.
Right, you're back with the Law Clinic. We have just one quick SMS I want to get through. It says, good evening, says this one. I would like to know, where is a will kept? We believe a will was made out to my dad in the late 70s.
Oh, goodness.
And I would imagine, back there, normally, in my view, with the banks, normally, they used to do them back in the day. It used to be the thing.
It depends who's done the will.
Well, that's it, I'm saying.
If it was done with a bank or an insurance company, then that bank or insurance company would probably store it. It's usually part of the service that they give.
Would they still have it, though?
They must have it, yeah. Wills are not stored like other documents that have a shelf life of 5 to 7 years, depending on the type. But there's no expiry date. And if it's been lost, then of course there's some action that could be taken against the institution.
But they don't know where, though. So I would imagine you'd have to go back and work out where your father had investments, possibly which banks he banked with.
If there was a
insurance
broker, maybe that advised, an attorney, that would be a good start. A family attorney that could perhaps have helped with the drafting and would have then also dealt with the storage. A safe. Going through all the at home.
Because normally they give you your own copy, though. You normally
yes.
have it, so there should possibly be a copy
somewhere
in the father's papers somewhere.
Yes, definitely. And I think it I know it leads into this naturally, but maybe we should just say this, that I think learn from this in terms of leaving notes or telling someone, where have you put your will? Maybe record some of the most pressing, important information. I have X amount of bank accounts at these banks. These are the account numbers. Don't write the PIN number, but
no.
Just detail what you have so that the person who has to go through all of this knows where to start.
I have that attached to my will with a paperclip.
Very, very, very good idea.
We mentioned me being neurotic in the beginning. Yes, this is just me proving the point. Right, so we all can learn from this. And tell somebody or leave a note. Somebody.
More than one person. Heaven forbid you tell your spouse and something happens to the both of you. So it's maybe good to give the person who you've nominated as the executor, email them a copy or give them a copy and say, it's over here. The original is over here. You can find it over there. But then at least they know what's in it, and there are no surprises. But again, it's a personal choice to what degree you want to share. But I would say at least tell more than one person.
Or you have a filing cabinet with a file that's got a label on it that says wills on it. Right, you should be able to find that.
Definitely.
As I said, sorry
Whatever
about that.
works.
But neurotic. Right, okay. We've got David on the line from the Eastern Cape. David, good evening.
Good evening to you, ladies, and thank you for a very, very interesting program that you run.
Thank you, David. How can we help you this evening?
Small claims court. What redress has one got if you're not satisfied with an outcome of a case that has been taken or handled by the small claims court?
Well, the normal rules of review and appeal would also apply in small claims court cases. So if you're not happy with the outcome, you can appeal it and refer it to the magistrates court, which is the next higher court in terms of a small claims court. And then if you're still not happy, then you can appeal it to the High Court, and so on and so on. So
okay.
You can appeal it.
Yeah. I've had, two experiences where in both instances I wasn't satisfied. In the first instance, it was a technical, well, when I say technical, it was a vehicle that was damaged. My vehicle was damaged by a guy who was found to have been driving under the influence of alcohol. And the vehicle cost me over 20,000 Rand to repair, and they said you could only claim up to 20,000 Rand. And when I claimed, the person that heard the case said that he didn't feel that the whole thing had to be, the cab had to be resprayed. It was a bakkie, because the vehicle was hit and very badly damaged. And in fact, if it, just a section had been repaired, had been resprayed, it would have been a different color because the other color had faded. And so he took off about 70% of the claim, because he said, he doesn't think, and he never saw the vehicle. He never, looked at it to see whether it should have been.
Strange.
And then when I queried it after, they said, no, well, once a decision has been made in a small claims court, there's nothing you can do except go to the proper court, but then you must get attorneys. You can't handle it on your own. You've got to get, somebody to represent you. And then in a second case, a similar thing happened where somebody, came and took some property and took a heck of a lot that they shouldn't have taken, saying they would sort out the payment afterwards. And afterwards they refused it and then disputed it. And because there were two of them and I was the only other person there, they decided that it was, two people's word against one. And there again, I was very dissatisfied with what happened because it was a total, almost a case of theft from, what occurred. And again, I went to a lawyer, I spoke to him privately, and he said, you can take it further, but you've got to go to a proper court then and appeal, and then it's going to cost you lawyers' fees, and it's going to drag on for years and years and years.
So,
It can, we always recommend that clients don't represent themselves in courts because we are trained to deal with it. We know the process. So the recommendation is not one from a place of saying you are legislatively or legally compelled to get an attorney to represent you in a different court to the small claims court. We are merely, as attorneys, we always recommend it because we know that it works a little better. You will be very frustrated if you end up representing yourself. So I just wanted to make that clear. There's no legal provision saying you are not allowed to represent yourself in higher courts. In other words, like in the magistrates court or the high court.
The bottom
We've
line
dealt
is
with many cases where clients represent themselves, and I must tell you are at a disadvantage if you choose to do that. But it's not, you are not compelled to use the services of an attorney. I would just say that it's preferable. So you do have recourse, but the reality is it will cost you a lot in time. Besides the legal costs for a minute, yes, it will cost you a lot in time. You will, if you are running a business, for example, it will keep you out of your business. You'll sit in the passages and wait for documents to be issued. You'll come back tomorrow or the next day, or documents may be lost or misplaced, and you'll find you'll be very frustrated. So it's not just a question of the cost that you'll spend, but I think you need to factor in the time amount. So what I've said recently to another client of mine who had to decide whether or not to take a matter further in court is you need to actually do a bit of a calculation. If on average, if all goes well, it takes about 1.5 years for you to see the inside of a courtroom. So 1.5 years worth of time in terms of spending at least 1 day a week, plus minus, on this case. It's in some cases it ends up being more. So compute what it will cost you to be out of your business or away from work 1 day per month for the next 18 months.
But the bottom line I just wanted to say here was that what do you do if this, I mean, because this sounded ridiculous. How would the person adjudicating this case have liked to have driven around in a two-tone car, for example? I mean, that didn't make any sense. There surely must be some way of actually saying, excuse me, but this was ridiculous, without having to spend your time and money taking it to a different court.
The only process is to appeal it.
At the small claims court.
Yeah, well, then the appeal process goes to the higher court.
Oh, so that's the way the lawyer. So you've got you can't escape that then.
No.
But that's just insane. I mean, there should be a way of saying sorry, but this was ridiculous. Some sort of place you could report it to, or is there nothing like that at all?
No, it's the court process has been founded over many years.
David, you and I agree this is something is not right. Maybe we should do something here, David. You and I. What do you think?
Unfortunately, it's
frustrating.
It's very frustrating, and it's equally frustrating for us as well, because unfortunately the reality is, if you look at the statistics, there are quite a lot of cases going to the small claims court and the lower courts, and I mean magistrates, regional and district courts that have the same unsatisfactory outcome. We face it every day, and the only recourse to our clients in that situation is to appeal it or to have the decision reviewed. So it depends what exactly you're unhappy with and what the paperwork looks like, and then you'll be able to see what is the most appropriate.
So what happens in the review process, though?
They basically review the process.
So you can take it back to the small claims court and ask them to review it, or ask somebody else at the small claims court.
You'll fill in the forms from the small claims court, and then it will go through the process.
David, there you go.
So there are two processes: appeals and reviews.
You start with the review thing. Go and see if you can't get that sorted out.
I think you'll have to look at the paperwork. Someone will have to guide you which one of the two processes is most effective. The appeals process is about the decision making, what the decision maker took into account, what process that they follow. So it's a much deeper process.
And what is the review?
A review is a little less, it doesn't go into the merits and all of that.
But they can look at the case
procedure.
and just see whether maybe they would have come to a different conclusion, effectively. Or
the one is more procedurally focused, and the other one is more focused on the how you've applied your mind. So you need to unpack the decision-making process.
But it's worth a try.
And it's worth a try.
David, there you go. It's worth a try.
To take the paperwork to an attorney, to get them to look at it and to tell you which one of the two processes would be much more cost-effective than just jumping into an appeals process.
Yeah, but look at the review, possibly, if that would work for you. Maybe
yes.
that would be something that isn't going to cost you money.
Yes, maybe so. So keep an open mind. Direct the details to someone that they can assess it properly and advise you properly what the best one of the two processes would be. And then do yourself a favor, if you have to decide whether or not to take it further to a higher court, compute what it will cost you in time and legal costs. People look at the legal costs and say, oh, it's going to cost a lot of money. You know what? It's going to cost more than a lot of money.
Because it's your time.
Yeah. And it's gonna cause a lot of frustration and emotional anguish that people don't factor in at the beginning.
I'm already getting emotionally anguished.
If you need to go there, then at least know what you're getting yourself into and assess whether or not it's actually worth it.
Good luck, David.
Good. No, thanks very much. I appreciate it, and I'd just like to mention that before I could even start this process. The police initially didn't do anything about the case. And when I queried it, about a month after it happened, they told me that unless you open the case immediately, the police don't follow up on anything like that. They just file the papers away, and I had to go to the local traffic department and get the papers from them, and then go to the police station, and then they hummed and hawed, and eventually they opened the case, and it was postponed umpteen times. It carried on for nearly, I'd say about 18 months before I actually got to the stage where the magistrate decided that this guy was guilty and fined him for, reckless driving and driving under the influence of liquor. And only then could I start the process of trying to claim the money back for the vehicle, the damage to the vehicle.
You're a much
sad affair from the word go.
You're a much stronger person than me, David. But thank you very much for the call, and good luck for the future of this case.
Thank you, and keep up the good work.
Thanks so much. Good night to you. We'll be back shortly.
You are an entrepreneur, a nation builder, a job creator. We can't imagine South Africa without your contributions, and we think it's time we recognized your achievements. Visit eoy.co.za and enter the 2017 Entrepreneur of the Year competition, sponsored by Sanlam and business partners. Let us celebrate your success. Entries close on 31 May. Entrepreneur of the Year competition, celebrating entrepreneurial excellence.
How can you future-proof your business? It's time to rethink how we do business and shift to the new paradigm of profit with purpose. Don't miss the Africa Shared Value Summit from 25 to 26 May 2017 at the Sandton Convention Center. Visit www.africasharedvaluesummit.com to book your place today. The summit is proudly brought to you by ABSA, Nando's, Enel, Nestle, and Shift Social Development.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
and we're back with the Law Clinic. We've got about 6 minutes left, and we've got 2 SMSs I really want to get through. The one says, I would like to find out what is my next step, because I'm trying to divorce my husband for 4 years now, and he doesn't want to sign the papers. I'm really tired of spending money on the sheriffs. What makes me angry is every time the sheriff has the papers, he goes missing, and all I want is for him to sign so this divorce case can go through. We don't have any children, we don't have a house. Basically, there's nothing left holding us together. What do I do?
Oh, goodness. Well, some practical advice, really. I would say speak to your attorney who's representing you, get a private investigator to get a proper service address, and for that person to accommodate the sheriff, the sheriff to do the service. That often works wonders. So if you find where they work, or where he's living, or who he's staying with at the moment, and if there's any maybe cooperation between him and the sheriff, then a third party accompanying them impartially that has an interest to get this done would actually help and go a long way. We've done that not on family law matters, but we've done that in commercial matters where we needed service to happen. So it costs you a little bit of money, but you get it done.
After 4 years, it will be worth it. Right, Don in Cape Town, good evening. Hello, Don. Hello, Don. I don't know, I think, there's something wrong. I can hear something on the line, but Don isn't there. We'll possibly not be able to get back to Don because we're now literally down to 4 minutes. So we'll go to another SMS, which says, good evening, I'm 65. I have no money or assets or a will, and I owe over 300,000 Rand in debt. I also have no insurance. What happens to the debt when I die? First of all, you need to make a will.
Yeah, we've covered this adequately in the program earlier. Definitely, you need to have a will. You can possibly wait for Wills Week and have one done then. If funds to have one done now is of concern. If no insurance is in place at this point, it's unlikely that an insurer will allow for a policy to be taken out at this late stage.
But he says I've got no money and I've got no assets and I owe over 300,000 Rand in debt.
So there's no solution to addressing the debt through insurance. If you don't have it in place now, no insurer will insure at this point in time. So, and if there's no income, if there's no assets, then it will be an insolvent estate in all likelihood. Whatever there is to be sold will be sold, and the creditor will get cents in the rand, if anything. So in simple terms, the debt will not be serviced by the heirs.
But the point is, don't increase that debt any further. Don't use this as carte blanche now to say, oh, well, I'll just go out and make it 400,000 Rand before I die. Don't do that.
No, definitely not. Definitely not. And this person does sound somewhat over-indebted to me, so I'm not sure how this came about. But hopefully there won't be additional credit that will be extended.
No, hopefully not. I'm not quite sure because there's no money, no assets, no will.
I mean, this obviously causes anguish. So
there must have been an issue that possibly happened here that has caused this. I don't think anyone would willingly get themselves into that situation.
No, hopefully not.
So,
but I agree. Don't see it as, okay, if something were to happen, no one will be burdened. The person who you're owing the money to will be burdened, because they'll be forfeiting what is rightfully theirs if there isn't anything to service the debt. So just make sure no one assigns surety for you.
Yes.
Because if they have, then of course it becomes their problem, regardless of whether there's a will or not, or insurance or whatnot. So I do think get some advice though. Share some more details, which are obviously not appropriate to do now in this setting, but go and speak to someone, lay it all out on the table and get some proper advice.
Okay, so there was just that thing about, because we've got about a minute and a half, well, about a minute left now, just some points for people to remember about the will and owing, because we've had 2 questions now tonight about what happens to all that money or the debt when I die. And the point is, as you said, a very good point we hadn't discussed before, if you have large amounts of debt and you don't know whether you're going to quite get around to being able to pay that debt off, please make sure that how do you get rid of a surety on something though?
Well, it depends what type of surety it is. If it's a surety that was casually given, in other words, it was maybe a family member.
They would have signed something.
Then you would have signed something, then you can just cancel the agreement. But if it's something signed with a financial institution, you are only released as a surety when the debt gets paid. So very, very important, particularly in student loans. Your parents usually co-sign a surety for you. So even the more, back to the point that we made in the beginning of the show, make sure that you secure those, get insurance policies in place, make sure you have that will and plan.
And this is something we need to pick up next time you're here. Maybe we should talk a little bit about sureties, because they always make me a bit nervous. My thanks once again this evening to Nicoline Skuman-Low. She's a director of Skuman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town and now in a brand new office. Nicoline, thank you very much for joining me again this evening.
Thank you for having me as always.
And Nicoline has been my guest on tonight's edition of the Law Report. She'll be doing another one on the 12th of June. And in next week's program, as I mentioned earlier, we're doing a special mid-month edition of Labour Law with Michael Bagram. That's the 15th of May, so join me then. Tomorrow night it's our monthly Health Matters phone-in. This month we're chatting about endometriosis and women's health. My guest is Lynn Zernarmer, so join me for that tomorrow. But it's time now for Stephen Kirker and some nighttime music. Hello, Stephen.